Nobody.
Remove her. You keep talking and there's going to be a problem.
This case opens in pure chaos, and that's not accidental. It's a warning shot. Before we even hear formal charges or bond arguments, the courtroom energy is already unstable. When a judge has to issue control commands this early, it signals that this hearing isn't just procedural, it's volatile. What viewers need to understand right away is that bond hearings in domestic violence cases are not neutral paperwork exercises. They are risk assessments. Judges are weighing patterns, not promises. You're about to hear repeated references to companion cases, prior violations, and alleged intimidation, all of which radically change how the court views this defendant. This is not about one incident. This is about escalation. And when a courtroom starts with raised voices and warnings, it tells you the judge already anticipates resistance. Ask yourself early, if this is the tone before the record is even cleanly established, what does that say about the court's confidence? In compliance? Stay locked in, because everything that follows hinges on whether the court believes its authority has already been ignored.
Work out the case versus Young.
Alexander, on behalf of the people, Your Honor.
Defender appearing on behalf of Mr. Young. Approaching, state your name.
Rashard Young.
Your Honor.
Yeah. Man. Okay, if it's you, Miss Linda, okay.
They're gonna fall for you.
Something you may want to, you may want to push that mic.
Oh, I'm sorry. This one.
Go ahead. While you're talking to him, you hold the mic, but I didn't.
Okay. Did you have other one? Is this your last one?
I only have one other case, but I'm not passing it.
Okay. You said just hold this down.
Yes.
Okay.
All right. Back on the record in this case. All right. Ready?
Your Honor, at this time, the people said it's 25,000 without the 10%. In this case, the defendant has a companion case in misdemeanor court 1482 from 2024. It's a DV assault with the same victim, and I believe her son. He also has a case out of Plymouth for a domestic violence with the same victim. And in this case, it is an FA with a knife in which he threatened the victim with the knife, took it out while they were arguing, pulled it out, brought it up, brought it down towards her. And while he was in custody from, I believe, 2-3 to 2-6, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment. We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim. And we'd be asking that at this time his bond is set at 25,000 without the 10% into custody, Your Honor.
This is where the prosecution lays its foundation, and it's methodical. Notice what they emphasize, not just the alleged knife incident, but behavior after arrest. 135 calls. That number matters. In bond decisions, post-arrest conduct often weighs heavier than the underlying charge itself. Why? Because it answers the court's core question, will this person follow orders if released? Prosecutors aren't required to prove guilt here. They're proving risk. Multiple courts, same victim, repeated contact despite explicit no-contact orders. That's a pattern, and patterns terrify judges. Even if the knife allegation were disputed, the volume of alleged calls alone reframes the defendant from accused to non-compliant. Viewers should ask themselves, if the court sets conditions and they're allegedly violated within days, what leverage does a lower bond really give? This moment is less about punishment and more about control, and the prosecution is arguing that control has already failed.
Response.
Okay. Regarding the actual charge, I did review the discovery myself. The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does deny all of those allegations. We have not received a violation report to discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through the evidence and possibly at that point we can, address Vonnegut at that hearing.
But he's indicating that calls were not made from the jail?
He's saying it was not him making the call. He did not make any calls to the complaining witness.
And I believe they were from his PIN to her number stated in the police report. And given that he already has multiple other cases with this victim, I have great concerns that he would still be contacting her out of custody.
I would ask, he is, okay, he is, your phone was. Oh, let me give you the iPad. It is my understanding that he is gainfully employed. He is a father. I would ask if he is, he can remain out on bond with a tether.
Well, but I'm a bit concerned about all of this contact. I mean, I've got these cases coming up while we were at the bench so that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th when he's released on that day.
Mhm.
But he's arraigned on the 4th, and it's clearly indicated he's to have no contact. So, and if it came from his pen, I mean, so I'll adjourn this to February 20th, 2025, 9 a.m. I'll adjourn it out 1 week.
Would we be provided with the calls?
Yes, I'll send those
Okay.
out to, or send the email to have those released today.
I'm gonna set his bond at $25,000 cash surety as the amount. What was his bond set at initially? Personal?
I believe it was the 25,000 with the 10%. And then the other case, he got a nominal $100 bond on the mistaken case.
All right. So defendant's gonna be remanded. He'll need to post that. And then at this point, defendant's phone privileges, given what the court has heard, are revoked. So that he'll go into the jail. He won't have phone privileges. Is the court's intention. And then you can get those through with your client, and we can figure it out next week. But at this point, defendant's remanded.
This is the turning point. Cash bond plus revoked phone privileges is not symbolic, it's surgical. The judge isn't escalating because of the charge alone, but because access itself has become the alleged weapon. Phone privileges are rarely revoked unless the court believes communication equals harm. This decision sends a clear message. The court views contact as uncontrollable and dangerous. Importantly, this isn't permanent punishment. It's containment pending verification. The judge even signals due process ahead. But for now, authority is being reasserted. Ask yourself, how often do you see bond decisions include communication lockdowns? Not often. This reflects a judge protecting the integrity of their own orders. The court is saying, if you won't stop, I will.
Yes.
This is that case, right? I'll recall the matter of the People versus Rashad Young.
Alex, and on behalf of the people.
Oh, there you are. Okay, I didn't know where you were at. It's like,
Ashley Moulton on behalf of Mr. Young.
yes, and Mr. Young, he was taken into custody, transported down. He is not here. I'm not bringing him back up only because my understanding is the alleged victim wanted to address the court. So we could get her. Your name?
Tandiana Yates.
All right. Ma'am, I'm going to let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up, and you probably would have been locked up. I'm just going to let you know, because you don't come into the court that way, ever. Am I clear?
Yes.
This moment is critical because it shifts perspective. The alleged victim addresses the court, not as a passive figure, but as an active, emotional participant. And while her intent may be advocacy, courtroom decorum still rules. Judges must balance empathy with authority. Notice how the judge draws a hard boundary. Emotion does not override procedure. This exchange highlights a misunderstood truth. Victims don't control prosecutions. The court does. And when someone challenges the accuracy of representations mid-hearing, judges respond carefully but firmly. Viewers should ask, does advocacy outside procedure help or hurt credibility? Because while the court listens, it does not surrender structure.
What did you want to tell the court, man?
Okay, first I want to say I fully apologize for coming in here like that. I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
y'all need to try to help him. I don't know if the prosecutor let you guys know, but he has a, yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that, but I'm
Well-
just going to let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court,
because I
and
feel like it
will-
was inaccurate.
I will
information.
listen to you. I'm not going to tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I would never do that, but I just noticed when I was looking on the Zoom that it was inaccurate information stated on you guys' record, and I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call, in this courtroom, and I just fully disagree with that, so I wanted to make that known.
Okay, let me just say this because you kind of blurted that out when you had come busting in here.
And my apologies for.
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here, his counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date, so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
Okay, so is there any way that a prosecutor, someone can call my phone so we can discuss this? Because I no longer have that cell phone number and it was to my sibling. You guys stated on,
If there are references to the case, ma'am, we thought about that.
okay,
If there are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it certainly, but at least preliminarily, what is being represented to the court appears to be true. And we will flush it out at a hearing because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. It seems that that was violated. He will have his due process right to a hearing next week.
This is the judge at his most instructive. He's clarifying a misconception many people have. Bond violations don't require direct contact. Indirect contact counts. Calls routed through numbers, pins, or third parties still violate no contact orders. The judge emphasizes process over emotion. Nothing is final, yet. But interim decisions are based on reasonable belief, not absolute proof. This reinforces the system's design. Temporary restriction now, full hearing later. The question for viewers is powerful. If orders are issued for protection, how aggressively should courts enforce them before irreversible harm occurs?
Regarding that,
but how is it violated when I have not physically talk to him. Just like when I came into the courtroom the first time and I sat down, he made it aware that I can't even be around him.
I
instantly
am
left.
not gonna have a hearing on it right now. I will listen to
Okay,
you.
that's just very, that was just very inaccurate to me, and I just felt like the way that y'all did that was no. Somebody should have let me
Y'all
know.
did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No,
You are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem. Ms. Cannon, do you want your cases called now? No, I'm good. I am so good, Ms. Cannon.
This case ends where it began, with the court asserting control. The removal isn't about silencing, it's about boundaries. The judge gave warnings, explanations, and opportunities. When those failed, enforcement followed. That's the judiciary's role. Not to debate endlessly, but to maintain order so justice can function. Looking at the full picture, multiple cases, alleged violations, disputed facts, and emotional volatility, the court chose caution over concession. The final ruling doesn't decide guilt. It decides safety, structure, and compliance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.